The immediate implementation in the days of the Founding Fathers, in many respects, was limited. We the people was not then what it is today. The most eloquent speaker on that subject was Justice Thurgood Marshall, when during the series of bicentennials, when songs of praise to the Constitution were sung, he reminded us that the Constitution's immediate implementation, even its text, had certain limitations, blind spots, blots on our record. But he said that the beauty of this Constitution is that through a combination of interpretation, constitutional amendment, laws passed by Congress, we the people has grown ever larger. So now it includes people who were once held in bondage. It includes women who were left out of the political community at the start. So I hope that begins to answer your question, that the view of the framers, their large view, I think, was expansive. Their immediate view was tied to the circumstances in which they lived.
Well, it does answer the question, and I'm delighted, to be very blunt about it, delighted with the answer. As I've indicated to you, and I've said on numerous occasions over my 20 years in the Senate, that I do not expect a nominee, nor demand of a nominee, to agree with me on substantive issues. But it does make a difference in me and give me, at least me, some insight into the view of the past history and the future of this nation that a nominee has, the vision they have, if I know from which they think, the place from which they believe our rights are derived. And you have made a fundamental distinction from other nominees that have been before this committee. You've indicated, as I understand your answer, that you start off with the position, which I happen to share, that this is a limited government. We do not derive our rights as human beings from a piece of paper called the Constitution. The government derives its rights from we the people. We the people got together back a couple hundred years ago and said, this is the deal we're going to make among ourselves and what power we're going to allow government to have.
American women owe much of their legal protection from discrimination to Ruth Bader Ginsburg, many years of work. Before she became a judge, she was a gender equality pioneer and an architect of women's rights movement. As a litigator, she led the Supreme Court to completely change how it viewed discrimination against women on the basis of sex. Paula Reed looks at Ginsburg's towering legal influence. Paula, good to see you. Listen, she was tiny in stature, but she was so mighty when it came to influence.
Good morning, Gail. Mighty indeed. Even before she was a justice, attorney Ruth Bader Ginsburg had already made an indelible mark in the fight for equal treatment for women. She was one of the founding members of the ACLU's Women's Rights Project, and while she was there, she came up with creative avenues to secure more rights for women and also try to move the country closer to a system where all people are treated equally under the law.
She has compiled a truly historic record of achievement.
Even before Ruth Bader Ginsburg was nominated to the Supreme Court in 1993, she had already cemented her place in history.
Women today face discrimination in employment.
Ginsburg argued 6 cases before the Supreme Court in the 1970s, winning 5 of them.
The Supreme Court today ruled unanimously that a widower with children is entitled to the same Social Security benefits a widow would receive.
Often securing rights for women by representing men being discriminated against in similar ways. Law professor Margot Schlanger clerked for Ginsburg during her first 2 years on the court. Can you point to specific rights that you and I have because of Justice Ginsburg.
Yes, absolutely. There was a time when women couldn't own their own credit card, when women didn't have the right to equal treatment in state-sponsored jobs.
During her first term, Ginsburg wrote a concurring opinion in a sexual harassment case that went farther than her colleagues, arguing conduct is illegal if it unreasonably interfered with the plaintiff's work performance.
She understood way before Me Too that avoiding sexual harassment in the workplace is a matter of equality, not just of avoiding boorish behavior.
That desire to fight for equal justice led her to a career centered around the fight to make the country live up to its founding ideals.
Think back to 1787. Who were we the people?
Who were they?
They certainly weren't women. The genius of the United States and our Constitution is that over now more than 200, sometimes turbulent years, that we has expanded and expanded.
Once she was on the bench, her fight for equality continued with landmark opinions, opening all-male schools to women and expanding protections for the disabled. Ginsburg was only the second civil rights attorney to ascend to the bench, and she ultimately attained this cultural icon status. I've been reporting here all weekend at the court, and I have seen hundreds of people coming here wearing T-shirts with her face on them. So many people coming here this weekend to pay respects for a woman who expanded freedoms for so many. Tony.
What a beautiful story, Paula, and it's a great way to remember her life as forever expanding the definition of we in the United States of America.